So today we're going to be talking about U.C.C. foreclosures, and specifically U.C.C. foreclosures following a default on a mezzanine loan. So mezzanine financing is distinguished from mortgage financing. When a borrower gets a mortgage loan, that is a loan that is made directly to the fee owner of the property, and it's secured by a mortgage lien on the property. Mezzanine financing is different in that a mezz loan is made to the entity that owns the property. It's secured by a lien on the borrower's equity in the entity that owns the underlying property. Because a mezz loan is secured by what we call an equity pledge rather than a mortgage lien, in New York, you can do what's called a U.C.C. foreclosure, which is a non-judicial foreclosure on the collateral. And this is distinguished from a mortgage foreclosure, which requires a lender to bring a lawsuit and go through a judicial process to actually foreclose on its mortgage lien. Before you start a U.C.C. foreclosure, you have to make sure that you have properly put the borrower in default. You need to ensure that you've sent all the required notices of default, any other predicate notices to a default or an exercise of the lender's remedies. Once you've done that, you're going to send out something called a notice of disposition. And in the U.C.C., it says exactly who you need to send this notice of disposition to. And in theory, you could do a U.C.C. foreclosure on only 10 days notice. We always make sure that there's at least 60 to 90 days notice from the time that we send the notice of disposition to the actual date of the auction. You don't want to be accused by the borrower of conducting a commercially unreasonable foreclosure sale in that you didn't give prospective bidders enough time to review the material, you didn't market the property enough, and so on. After your notice of disposition goes out, it's important that you immediately start marketing the underlying collateral. You should be putting out marketing materials, and we often will go ahead and hire either a broker or a marketing firm to make sure that the equity is properly marketed. This will often include publication in various newsletters, and depending on the nature of the collateral, having the broker go out and approach particular prospective buyers or prospective bidders. As the lender or the secured party, you also need to put together a data room of relevant documents. In this data room, you're going to put the loan documents for your mezzanine loan, as well as the loan documents for any other loan that is out there, such as a mortgage loan. To the extent you have a payoff statement from the mortgage lender, at least as of a particular date, I would include that as well. A prospective bidder that is functionally buying real property that is subject to a mortgage lien wants to know how much is actually owed to the mortgage lender. Now, sometimes you can't get a payoff statement from a mortgage lender, and you shouldn't make statements or representations about the amount of the mortgage debt if you don't actually have the information. But to the extent you do have a payoff statement or some type of representation from the mortgage lender, you want to include that. You also want to include in your data room financial information that you've gotten from the borrower. Now, oftentimes this financial information is not going to be up to date, and you'll qualify that when you explain to prospective bidders what's in the data room. But if you have the information, you should give it to prospective bidders. And if you fail to do this, the borrower could come back and say that you didn't give the right information to prospective bidders, and as a result, the market didn't have enough information to be able to assess the value of the collateral. You're also going to have a confidentiality agreement, and anyone who wants access to this data room is going to be required to execute that confidentiality agreement. Along with the notice of disposition, you're also going to prepare a document called the terms of sale. Now, the terms of sale can either be attached to the notice of disposition, or it can be a document that a prospective bidder has to request from you. The terms of sale are very important, and if a borrower is looking to challenge whether a U.C.C. foreclosure was conducted in a commercially reasonable manner, they're usually going to go to the terms of sale and try to pick out things in it that are potentially onerous or done in a manner that are not commercially reasonable. Now, borrowers often challenge the amount of a deposit, the amount of time that a winning bidder has to close, indemnification obligations that might be due to the secured party. It's common in terms of sale for prospective bidders to have to be qualified by the lender in order to actually bid at the foreclosure auction. Usually, the terms of sale will require prospective bidders to present some type of financial information or proof of funds to the lender before being permitted to place a bid. And the reason for this is that the lender wants to ensure that whoever's showing up to bid actually has the money to close on the deal. It's also common for a winning bidder to be required to put up a deposit, often approximately 10%, at the actual auction. Now, what that requires is the winning bidder to show up with money in hand. Usually this will be in the form of a bank check. The terms of sale will then require the winning bidder to close within a certain period of time. This will usually be a week, 2 weeks, at most a month after the auction takes place. Finally, you're going to have the actual auction. To do this, you need to hire an auctioneer. There are a lot of people who do U.C.C. foreclosures as a living. The auctioneer will show up, will take whatever bids are there, and then will declare the winning bidder. And then the winning bidder will execute some documents to actually close on the underlying purchase. Most U.C.C. foreclosures don't actually involve anyone showing up other than the lender or the secured party. And most of the time what's going to happen is the lender is going to make what's called a credit bid, which is a bid for the property using some portion of the debt that the borrower owes to the lender. So for example, if there's a $30 million loan that's owed to the lender can show up and make a credit bid of $1 million. And the lender doesn't actually have to put up any cash. Instead, that $1 million will be the purchase price, and the borrower will still be on the hook for the remaining $29 million. Now, from the lender's perspective, oftentimes what you're looking to do is craft these terms of sale in a way that discourages bidders from showing up, but does so in a commercially reasonable manner. Now, most U.C.C. foreclosure auctions end with a credit bid. Even if you as the lender believe that no one's going to show up to the U.C.C. foreclosure auction, it's still critical to ensure that the process you go through is commercially reasonable. Because if it's not, the borrower has an opportunity to come forward and either stop the auction or assert a claim for damages after the auction. Even if nobody showed up, this violates the U.C.C.